Good morning, everyone. It is Monday. Beautiful day. Great to be alive. It certainly is. We had one more beautiful summer weekend this weekend. Put my boat away tonight, but we had a great weekend and company from out of town. And Judge Pattison is back. I'll catch up with him a little bit. Can you handle that one bench warrant for me? I gave it to Jeanette. It's a no ops. And you got the public defender on your side, and so she's got it. He's in custody, but it's a dumb.
Was it Polycom? Yeah, I'm not sure when I'll do it, but
Well, I didn't think it was gonna be till 9, but Jeanette's got it, or she gave it to Jen, but I'll catch up with you.
okay.
We had a wonderful funeral for my friend. A lot of visitors came to town. Some stayed at our house. And it was good to see our friends. About 20 or plus of my classmates were there. Anyway, after today, it's gonna drop by 20 degrees, and this false summer we've had will be over. But October 5th is the latest I ever remember swimming in the middle of the lake. Quite invigorating. It's good to have Judge Pattison back. The magistrate is still not back, and the court administrator is gone, but we'll be here. I've already got somebody in the waiting room. If you're a Lions fan, good weekend. If you're a Cincinnati fan, maybe not so much. It was like 85 yesterday. It's supposed to be 80 today, and then tomorrow it's supposed to be like 58. So our little dose of humanity shared experience is a song I like. It's got great words that are easy to sing along with. I actually prefer the cover version to the original. The cover, give you a hint, is by Linda Ronstadt. If you don't know the song, you might want to listen to it. If you do know it, maybe you'll remember it. Anyway, today's opening line is, I hear mariachi static on my radio, and the tubes, they glow in the dark. I'm there with her in Ensenada, and I'm here in Echo Park. I like that song a lot. It was nice to get a nice little email from Brian. Thank you very much. And Jim in New Jersey. Nice to hear from you. We'll see you soon enough. And I hope you like today's opening line. It's a great song, although it's very dark. I guess I've got my customers in the waiting room. So I better go ahead and start. Thank you all for saying good morning. Any sign of Teresa Standish? All right, thank you. Bye. Somebody, was it you, Matt, predicted that she wasn't going to be here, or somebody?
I don't know if I made that full prediction, but
You were fearful?
that was good.
Well, let's call that case and free up Mr. George. It's actually got two components. People versus Teresa Maria Standish, file number 251677, alleged that on June 6th of 2024, the defendant operated while impaired by a controlled substance and did possess a controlled substance. So it was a drugged driving case, operating while intoxicated by a controlled substance. It was set for a screening, and Mr. Huff prepared the screening report. And he and I had to touch base on this a couple of times. She is not doing well. Subsequent to that, on July 5th of 2025, she got a new charge of operating without a valid operator's license. In that case, it's just kind of been percolating around out there. She didn't show up for arraignment. Then she pled not guilty, and I appointed Mr. George and set that for pretrial along with this case. We also learned that she has an open warrant for her arrest from circuit court for failing to appear there. She has a long history of opioid abuse as well as other substances, methamphetamine. She was very debilitated at the time she got arrested. And this, again, was more than a year ago. One of the reasons it was so old is because she didn't get arrested until August of 25. Now she did appear for her sentence, for her screening. How recently was that?
That was last Monday or Tuesday.
Have you had any contact with her since then?
I have not, Your Honor. And just so the court's aware, the new case, and I wasn't aware of this at the time that we entered the plea, is written under ordinance.
It says ST.
It's
It was 8th and
oh,
Mechanic,
it is.
I
I'm
think
sorry.
it is ours.
but it is
Sorry.
Yeah. I
So
think
we
it
don't
is
have an
It's a-
issue on
We
that.
But
thought
it's
there
a-
may
I
be a
thought it was
conflict.
city, so
but
I
it's
asked.
a TRPD case,
Right.
so arguably there is a conflict. But and you and I have had, why they keep doing that, I don't know. They're gonna write it under ordinance rather than state statute. I think they just clicked the wrong box. These officers don't remember when you actually had to write a ticket. Here she is. Ms. Standish. She's here. She's late. Hi. Could you do a test for me on Teresa Standish? Yes, she is. All right, thank you. Okay. Ms. Standish, before we begin your case, this is 251677 FY. We're going to do a drug test. We're going to have you take a urine test this morning to see what we're dealing with. You're late. We called the case at 11, but just wait a minute. And Ms. Kiefer will come up and help us, and we'll do a urine test and see what we're dealing with. In the meantime, Mr. Workman, I guess that means we're ready for your case.
Okay, yes.
This is file number 251381ST. People versus Michael Anthony Haida. Good morning, sir.
Good morning, Your Honor.
I've met Mr. Haida at his arraignment, and I think later pretrial and plea. He's here with his lawyer, Mr. Justin Workman. This case is interesting for a couple of reasons. Mr. Haida is from Midland. We don't get a lot of cross-pollination between Midland County and St. Joe County. I went there a year or so ago for a conference in a very nice town. The former prosecutor was a good friend of mine. The current judge is a friend of mine. You also got some evaluation services that we don't normally see. And I enjoyed this report that I got from your treatment provider. This is a situation that happens several times a year. Somebody's here for a wedding. They don't know where they are. There's a wedding reception, there's alcohol, and they get arrested and to get to visit the St. Joe County Jail. Daniel Frazine has prepared the screening report. As I said, we had a nice treatment report from your provider, I think at Central Michigan University. And I learned something about it. As far as I can tell, you have zero, as in no criminal history whatsoever.
That is correct, Your Honor.
All right, Mr. Workman, what would you like me to know?
Thank you, Your Honor. I have reviewed the substance use assessment as well as the report from probation. I think that it is pretty clear to everybody that Michael made a mistake here and he's trying to own up to that, but also that this is not an ongoing problem. It hasn't been in his past, and it doesn't appear to be a problem that he's going to have moving into the future. This is somebody who made a big error in judgment, is trying to take responsibility, and this court will not see him. And I don't anticipate any court is going to see Mr. Haida in it moving forward. It is on the line. I think that would be an agreement with probation on whether or not this is one that is appropriate for probation or not. We are asking the court to consider fines and costs as a resolution in light of the documentation that was provided on his substance use. Thank you.
And that is the substance abuse evaluation you're referring to from Perspectives Psych in Midland. Is that correct?
That is correct, Your Honor.
The bottom line is they said Michael does not meet the criteria for a substance abuse disorder. It is recommended that Michael participate in alcohol or other drug education course at their center. Essentially that's it. Daniel Frazine has prepared the screening report. I'll give him a word in a minute, but Ms. Camfield, what's your thought here?
Well, Your Honor, I will note for the record, thank you, Mr. Frazine. He did just provide a copy of the substance abuse evaluation to me today, but I did have his guideline scoring as well as his substance abuse assessment report. Just got the Perspectives one today. I have a tendency to disagree sometimes with these private evaluations. I mean, he's born to a father who has mental health and substance abuse issues and drinks alcohol in excess. He started consuming alcohol when he was 16. He's used other substances such as marijuana and tried psychedelics, mushrooms, acid a couple of times. Obviously, it appears that those may have been while he was in college. Still says that his preferred substance is marijuana. But he drank to excess here, and he was on our roads, and we just had another fatal accident over the weekend,
Yes, we did.
which I'm sure we may discover involved alcohol or substances.
So about the motorcycle accident?
Yes. So it's becoming very concerning. Yes, he was here for a wedding. No, he doesn't work here. No, he doesn't reside here, but probation can be transferred. I do think that he needs, that the presumptions overcome here. Self-reporting is always a little questionable to me, particularly from a younger individual, as to whether or not they need more assistance than they're willing to admit. He claims he just got in to drive the vehicle to follow his friend home rather than riding with them because it was too crowded.
I haven't figured out where they were coming from. I'm going to ask him. They were coming like up Lutz Road or something when it turns into South Main. It was at a weird place. I thought this wedding was like out in Jones or something. So I don't, he doesn't know where he was coming from, but wherever it was, there's a lot of twisty, turny, hilly roads between where he came from and where he got stopped.
So I tend to disagree with defense counsel here. I think that it's more than a fines and costs. I think we've overcome the presumption. I would like the court to sentence him to probation. I have no disagreement with that transferring up to county of residence if they will accept it. I do think he needs to attend a victim impact panel, and I think he needs some substance abuse treatment, at least some initial classes on consumption and safe driving and things of that nature. One should have had that common knowledge, being 30 years old, but driving with a .163, he was almost a high blood alcohol level warrant as opposed to a drunk driving. So that's concerning to me as well. I think that the recommendation is appropriate, and I would ask that the court follow it.
I've been on a shared concern that we've become numb to high blood alcohol levels. You think, well, the guy was only at .16, but that's 2 times the legal limit. People are drunk at .16. I do not have a problem with having this been reduced to impaired driving. Defendant's working on becoming an electrician. He'll need his license to get back and forth to work. So I don't have a problem with that. But Daniel, you're recommending probation. You state the reasons why, but anything else you want to add to this?
Oh, no, Your Honor. I think that the reason that he was following that, there were a lot of twists and turns, and I think that's part of the reason why he followed so closely. He knew he was a little bit on the buzz side, and I think he didn't want to get lost, and he wanted to make sure that was kind of his, like leading a dog on a leash safety net. Obviously not something we want to use as a safety net, but so I think there was some thought there. I think this is somebody who was at a wedding, so it's not something he does on a daily basis. I did, being in the trades and a journeyman carpenter myself, I did have some discussions with him going into the trades about how this can easily blow up in that career field. So we had a very frank and honest discussion about that, and I think he's able to apply this and will be able to apply this. But I definitely think that a term of probation and some education would help him along the way, Your Honor.
You state, Mr. Hyde had presented as a respectful young man who was very likely to avoid this kind of risky behavior in the future. However, due to his high blood alcohol level and the fact he said he should not have been driving, I believe a short term of probation with substance abuse education is appropriate. Ms. Canfield spoke to the report. The reports are inherently problematic because they often get most of their information from the defendant. And I've had reports that I strongly agreed with. Defendant has a prior, his blood alcohol was 2.4 and he was drinking straight vodka on a Tuesday. And the reporter says, we don't think he has a substance abuse disorder. Those are important because you need those sort of evaluations to get into sobriety court. And, but I think you were upfront with the officer, you were upfront with your treatment people, but I think you need a timeout, which is why Daniel's recommending this probation. Mr. Hyde, is anything that you wish to tell me?
No, Your Honor, I think all the facts have been presented correctly, and I don't have any arguments against any of them.
All right. This place in Midland seems like you can get what you would need for that. I'm not going to order any additional jail time. Once upon a time, it was presumed that everybody in a drunk driving case got some jail. Not now and not after the Auburn Hills case where district courts are supposed to do proportional sentences. You were polite, respectful with the officers. You have no previous criminal record of any kind. I don't think even a traffic ticket. Your blood alcohol was 2 times the limit, but I'm not ordering an additional jail unless you somehow bomb this probation. One of the conditions of the probation is you not drink any alcohol or use any marijuana or other controlled substance for a period of time. The fine is $300, a $75 crime victims' rights fee, $50 state minimum fee. I'm gonna cut the screening fee in half to $50. Mr. Workman's firm does a good job of getting people in a position to get sentenced. Did he do a victim impact panel yet, Mr. Workman?
He did, Your Honor. I have a copy of that today. I think I also sent a copy to the probation
Yeah.
department on Friday.
That's another thing that your
Your Honor.
firm does, yeah?
Again, I have to address Mr. Workman. Please send copies to the prosecutor's office as well.
I don't, yes, I would agree. I don't have it.
I don't,
I didn't see it either, Your Honor. VIP, I didn't see.
and I prefer that those be attended in person.
What was it? His
What?
victim impact panel.
Ma'am?
And just to be clear, those are unable to be attended in person, so.
Where was this done?
That's done online at the Mothers Against Drunk Driving website.
Yeah, I'm not a big fan of that either, but,
And again, to be clear, that they cannot go in person, so it's not.
well, I mean, this is an option that they have. Ours, the impact of it was being in a room with someone that had some devastating consequence. Watching it on video was much less. Although frankly, I think we're doing a lot of videos now, aren't we?
They still attend in person for our VIP unless they're Spanish and they watch the video.
But their VIP is in a room with other people, but you don't have a live speaker.
No, I don't think we've had a live speaker in a while.
Yeah, so that was the hard part was getting the speaker. I started our victim impact panel when I was prosecutor, and my victim advocate, Linda Baker, and I would contact people that we had known who were victims of a drinking driving case. And it was powerful. It's much less powerful to sit in a room with a bunch of people that smell like cigarette smoke and watch a video. But that's the world we live in now. So he could watch it on video there or watch it on video here. So I'll accept this. But again, this Campfield makes a good point. If you're going to share it, make sure the prosecutor, give that to Daniel. $240 probation oversight fee, police reimbursement of $120 to Three Rivers PD. And what they recommended, that he participate in the drug and alcohol education class at J&A Counseling. So that would meet the criteria. He's done the victim impact panel. They've apparently got some program in Midland that could meet that requirement. So basically, no drugs and no alcohol for the next 6 months. We call it a timeout. You're 30. I don't think you're too far down the rabbit hole. I think this was a wedding. Like I said, this happens every year, usually in the summer. I've told a story that I was at a wedding reception and I saw the guy and he left and he got arrested between the wedding reception and his hotel room. And I had to disqualify myself because I was a witness because he was drunk. But it happens several times every summer. All right. You're going to do the substance abuse counseling treatment is directed, alcohol testing is directed. No drugs and no alcohol. You're not going to do any additional jail time if you do what I ask you to do. They're recommending an alcohol and drug education class in your hometown, which we should be able to set up. Right now, what sort of project are you working on?
I'm sorry, Your Honor, what sort of project?
Yeah, do you have a project right now for work?
Currently I'm working with my friend, David at the drywall company that he owns. This is just temporary though. I was kind of waiting to see the result of this trial here and I've got a bunch of resumes lined up.
How far are you towards getting your license?
My electrician's license?
Yeah.
This is my first semester at school for that.
So you're at Delta College right now
Yes, Your
and
Honor.
working drywall on the side?
Yes, Your Honor.
All right. Well, those are worthy. Yeah, they don't just hand out those journeyman cards like bubblegum stickers. You got to earn it. All right. I don't think I'm going to see you again. I'd be very surprised if I did. We get several hundred drunk drivers every year. We're on a bonus this year. It's October. I don't know how many we've had, but we've had lots of them. And Miss Camfield also remarked we've had lots of fatal accidents, including on the road you were on. And a high percentage of them I don't ever see again. I think you're gonna fall in that category, but there's a bunch of them I see a lot. All right, you go with Mr. Frazine, and he'll coordinate this. What you're gonna do up in Midland. And that will be better for you. And your restricted license will allow you to drive to and from work, education, treatment. You can't go to the golf course, you can't go to the movies. Theoretically, you can't even go to the grocery store, but they allow people to do that on the way home from work. So it's gonna be restricted for a period of time, and then it will be restored. In the meantime, you're free to go.
Understood. Thank you, Your Honor.
All right, good luck, sir. How are we doing with Miss Standish?
She's out there drinking water.
Oh, she hasn't peed yet?
She cannot go back, to the bathroom, so.
That's what automated she couldn't.
All right. Oh, well, wait,
You want to wait for that?
yes, I do.
You have other hearings you're gonna go to?
No. Well, let's go ahead and talk about it. She isn't going anywhere. This is file number 251677, People versus Teresa Marie Standish. She's here with her lawyer, Mr. Tim George. She also has a traffic ticket from July 5th of 2025 for driving without a valid operator's license. It was written under state statute, and I assigned Mr. George to that case, but it was written by a Three Rivers police officer in the city of Three Rivers. And Mr. George is the city attorney for Three Rivers, so that is a little bit difficult. So I'm going to set that aside for a minute. Let's talk about this driving under the influence charge. It's bad. You're zoinked out in the middle of an intersection. It was charged originally as a felony. It took a year or more for you to get arrested on it. It happened on June 6th of 2024. It was authorized by the prosecutor, Ms. Camfield, on August 11th of 25. So it took more than a year before it got authorized. And then shortly after that, he got picked up. I think some of that had to do with waiting for the laboratory reports, and I'm not sure what else, but, and then in the meantime, before you even got arrested for this, you got charged with driving without a license back in July. All right. Mr. Matt Huff has prepared the screening report here. And this is a history of addiction to mostly opioids, but other stuff. You had a previous operating under the influence of drugs. You were in Judge Stutzman's adult treatment court, which you failed out of. And now we have this. You were passed out in the middle of the intersection with a needle next to you, and you had some weak sauce story about what happened. But they found amphetamines and methamphetamine in your laboratory blood analysis. So having said all that, Mr. George, what's your thought here?
Well, Your Honor, I've had the opportunity to represent Teresa in the past, and as the court had indicated, one of the common themes is the substance abuse. I think what Mr. Huff's recommendation does is give her the opportunity to afford herself of services. She desperately needs the services. I know that she had an unsuccessful discharge from adult drug treatment court, and that's probably the most intensive, resource probation that we have here in this county. But I think it's worthwhile to try to get her engaged in these resources. This is a scary situation. This was the first time, at least, that I've had a case that involved this synthetic opioid. I hadn't seen it before, but that in and of itself is a very scary situation. It could have ended much differently. But fortunately, she is here. She does indicate that she does have employment. Obviously, there's going to be concerns with her driver's license going forward, but it's all on the table for her to take these resources or to just do a significant amount of jail. And I think that she's in a place right now where she would like to have that opportunity. And if for some reason she isn't able to successfully complete it, then she knows what the outcome is.
Ms. Canfield, what's your thought?
Your Honor, I've looked at Ms. Standish's history, being somewhat new to the county as of July, but I've looked at her record. I've looked at the unsuccessful adult drug treatment court. In this particular situation, not only was she slumped over the console in the middle of an intersection with the vehicle running, albeit in park. There had been evidence from the caller to the officer that she'd driven off the road through a field and ended up passing out in the intersection after placing the vehicle in park. So there was damage to somebody's field or property. I don't know which farmer that may have been or if restitution was requested, but she had gone off the road. And in addition to the amphetamine and methamphetamine in her system, the laboratory report also showed TSH or THC, excuse me, present. And then in the vehicle, another laboratory report was conducted on a substance found in a white bindle, and that was protonidazine, which is becoming, unfortunately, a lot more popular on the streets. It is a synthetic opioid, and it is extremely dangerous. It's more functionally powerful than fentanyl, which a very small amount of fentanyl can kill someone. But now people are starting to get a hold of this for their opioid addiction. I think that this hopefully would be a wake-up call for Ms. Standish. Had she consumed that with what she also had in her system, we likely would have been responding to an overdose, if not a death, at that location instead. And it's a very real threat to her. I don't know that she's ready for the services. She's had opportunities before. She's been unsuccessful, and those have been very intensive. She was an adult when those services were offered. I just think that the only resolution here, unfortunately, is a lengthy jail term where we can at least conclude during that time she would be substance free, and perhaps she can get out and then seek some additional services for herself in an in-treatment or intensive outpatient program once she's had a long period of sobriety. But she's just clearly not able to do it on her own. And I think showing up today without the ability to take a urine screen, thinking that the court would likely request one, is a little bit problematic as well. Because any water that you drink in order to be able to produce is going to dilute that.
I don't think if we get a sample, I don't think it'll be diluted, but I'm just wondering what we're dealing with right now.
Or creatinine level will be off, so it'll be hard to tell if it was.
Ms. Standish, if you do produce a urine sample, what would be in it?
Marijuana and possibly methamphetamine. But
When- When did you last use methamphetamine?
2 weeks ago when my uncle had passed.
Who's your uncle?
Mike Garcia, and then I just had a death last Friday of my aunt, Yvonne Torres.
I saw
in
that.
Hammond. But I'm on my Vivitrol. I just went and got my Vivitrol shot Friday.
Well, Vivitrol can be effective for alcohol, but not so much
It's
for,
for opiate use. That's what
And-
it's for. I've been
and
on it since I've gotten out,
yes.
and I've been staying out of trouble. I've been trying to get my life back on track. Been working. I haven't had any other.
Where are you working?
I work for
Oh,
my
your
son,
nephew, yeah,
my
that's
son.
screwy, Louis, side job kind of thing.
Yeah, no,
Yes, you're on Vivitrol, which is primarily for alcohol. But it also can be used in opioid situations, so you are plugged into Pivotal. One problem with this case was more than a year old before it even got here. And I don't completely understand all that. So it's very old. And then in the meantime, you got this other ticket. Now, how'd you get here?
oh, I had my friend drop me off.
All right, who dropped you off?
Her name is Christina. What's her last name?
All right, she didn't drive here.
160 Spanish Drive.
All right, I think probably she did. Now, did anybody tell you Judge Stutzman has a warrant for your arrest?
I just took care of that. I just made that payment.
Double check the video, so.
Stutzman's probably on the bench. I don't disbelieve you, but I'm gonna make sure. Hi, Ruby. Did Teresa Standish stop up there and get her warrant recalled? So you still have an open warrant for her arrest? All right, thank you. Bye-bye. All right. There is still an open warrant for your arrest. You haven't stopped up there.
No, my mom is making the payment.
Hasn't,
Like, I had called.
yeah, it hasn't reached it yet.
Okay,
And your mom didn't do it as you, and you're old and your mom's still carrying your water. I want to test, and so we're gonna wait till you can provide a sample. Do you think you can go now?
Fine.
All right, Autumn, could you rejoin us? When you say, I think I might be positive for methamphetamine, methamphetamine isn't something you just dabble in. It's so highly addictive. You don't do some on Tuesday and then some later, a week from Wednesday. I'm very interested in where you got this stuff. Now, again, this was a year ago. So there are even newer substances newer than that, which are also very scary. The stuff gets made faster than we can keep up with it. For Mr. Huff's purposes, he ordered or he recommended that I hang a bunch of gel over your head. I don't know that I really want you on probation. There's a whole bunch of probations in your past. And I think you're still using methamphetamine while you're on these other treatments. And I guess I don't think you're under a condition that, well, if you're not on probation at Judge Stutzman, you're just paying.
Yeah, I'm just paying $5.
So I guess it's legal to use marijuana. Let's see if there's a bond condition. Let's try again. Thank you, Autumn.
I don't believe that there is, due to the nature of how she was arraigned.
May not consume alcohol anytime or any controlled substances. And its question is whether marijuana is a controlled substance. It's not actually. It's not under state statute. It is under federal law. So mine are specific. They include marijuana, but I'm not sure. And then I don't know what to do with this traffic case. I don't want to put you in a compromised position where it's a state statute case, but it is a Three Rivers PD case. Ms. Campbell, do you have any thoughts on the traffic?
Well, Your Honor, I've taken a look at that, and frankly, if the courts intend, I'd like to wait till this sentencing is
All right.
completed, because if there is a likelihood of incarceration, I'm probably not going to bother moving forward with the
All right.
traffic citation.
And again, she didn't show up for arraignment.
Your Honor, I also, for myself and Mr. George's information and Mr. Huff at the court, if I'm looking at a research paper on the elimination rate of methamphetamine, it has a half-life of 10 to 12 hours. So at the conclusion of the first 24 hours, approximately 2/3 of it would have been eliminated by the body. So I guess arguably, if she is positive for it today, but claims she only took it 2 weeks ago, that's not truthful.
I think that if she is positive, I don't believe she took it 2 weeks ago. As I said, my position is that I'm afraid that she's still actively using it. So we have a lot of people, we have a lot of methamphetamine cases here, and there's a more recent phenomenon where people are using methamphetamine and opioids. That's not limited to St. Joe County. Both of them deplete all the dopamine from your brain, but methamphetamine gives opioid addicts enough ambition to get up and get more opium, get more opioids, heroin, fentanyl, this stuff, and you have to pay for it. And these tests are not as inclusive as a laboratory test, but that last guy, I did the sentence and I forgot to take into account the fact that we had some cash bond money in the file. They'll figure it out, I guess, when they get there.
So confirmation she did not drive.
Very good. I believed her. What do we know?
She's positive for methamphetamine, admits use, marijuana, admits use, amphetamine, which is the byproduct of meth, also oxycodone. Claims her Vivitrol would be positive for that. I would have to verify that. I'm not aware of that 100%.
All right, thank you.
Mhm.
I do believe that's true.
Yeah,
Vivitrol
the
will show up for
Vivitrol.
oxycodone.
All right. Okay. All right. Ms. Standish, I don't know what to do here. This happened last June. It's now October, 15 months later, and you're still in the pits. I'm gonna order 91 days in jail, credit 1, leaving 90 days to serve. Fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee. I'm gonna waive everything else. $125 or 2 additional days in jail. You're just gonna get some forced clean time. And Matt mentions this in the report. This is deja vu all over again. This is the second time you got convicted of this, and the facts are very similar to the first case. You're still using, you're still minimizing, you're still struggling. You need to just get some clean time. you owe $125 or 2 additional days in jail. There is another case, 251301 ST, the no valid operator's license. Ms. Campfield, what do you wish to do with that
Your
one?
Honor, the people moved to dismiss in light of the jail time she'll be serving on this matter.
All right, well, that's a break and a blessing. Gonna save you some money and 2 points. And you did not drive here. You did tell me the truth about that. But you didn't use methamphetamine maybe you did use it 14 days ago. You also used it yesterday or 2 days ago or this morning. But Ms. Standish, you're gonna come out of jail with a clearer head. Maybe, we can start from there. All right, you can go with the officer.
Sir, what was the main charge?
Operating while under the influence of a controlled substance. Well, you got a little bit of a morning here, some of each. No case is easy and no case is exactly like the other one. One option was to try to put her on probation and hang a bunch of jail over her head, but she just needs to get straight. And this ain't gonna do it. It's just gonna keep her in jail for about 75 days. She'll detox and she'll go back on her Suboxone or Vivitrol. All right, Yoder's is that way and that way. I'll say hello to you tomorrow when I open. Did you know today's first line?
Oh, no, we missed it this morning.
Yeah, I guess you were here. The song is called Carmelita. It's by Warren Zevon and Linda Ronstadt does a beautiful version of it. It's about heroin addiction. So kind of the theme of the day. Today's song was Carmelita, Matt, by Linda Ronstadt.
Good to know. I'll note that.
All right, you can listen to it. I don't know, you probably don't know it, but it's a pretty song, but it's about heroin addiction. Well, it's nice to meet you both. Thanks for coming.
Thank you.
Angelica, it's nice to meet you too.
Have a good day.
You've got good insight and you've also got institutional knowledge about things like how long it's going to stay in your system or what this was or this was. So it's a pleasure to have some experience here in our.
I'm glad to be
Arena.
of help, Your Honor.
Thank you. This poor lady's just gonna be where she's gonna be for a while. I was hoping this case was done, but it isn't. This is file 242120. This involved a long testimonial case about some lawn furniture that this family bought from Ashley Furniture. We had a hearing, which was set for March 10th, and nobody appeared on behalf of Ashley Furniture. And a default judgment entered at that time on behalf of Miss Manley in the amount of $1,735.42. In an attempt to collect on that, and then I got a motion from the. Oh, you can have it. One of our cases has been dismissed. Then there was a motion to set aside the default, which I declined to grant. And so the motion, the judgment stands. And that was on April. In order to set aside a default, in fact, it's not even exactly clear whether you can even do it in small claims court, but I had a hearing you have to show a legitimate defense and good cause for not appearing. I didn't find any good cause for not appearing. So the plaintiff then did a subpoena to discover the ability to pay on this debt, and nobody appeared from Ashley Furniture for that. So we set a show cause hearing regarding this. So, Mr. Kloppenstein, thank you for being here. Miss Manley, you as well. Mr. Kloppenstein, will you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
You so far have got about $10 zillion worth of bad publicity out of this case. I found on her behalf by default in the amount of $1,669.17, $62.28 for a total of $1,735.42. She wanted to add some other items, but they weren't part of the original complaint, so I wouldn't allow them to be added. You moved to set it aside. I denied the motion to set it aside. She did a subpoena to collect. She wants her money. You may feel that she was already made whole. She got the furniture returned plus other stuff, but this judgment entered by default. So the ship has sailed. You owe that amount of money. Do you have the ability to pay that?
Your Honor, we did switch out the piece for her.
I got it. I got it.
Okay, okay.
But then the lawsuit was still going. You didn't show up, so a default entered on her behalf. You had a motion to set aside the defense. The default, you may have had a meritorious defense, but you didn't show up for the hearing. And I had a hearing to find out why, and there wasn't good cause other than, I guess they forgot. So, yes.
Your Honor, I was out of the country and I did not know about it, but we thought it was made whole by exchanging the piece.
I understand.
We thought it was made whole.
It wasn't. And I didn't like entering the default. I thought she got paid twice. I thought she got made whole, plus she got $1,600.
Yeah.
But you got notice, there was a hearing, she was here, nobody showed up, and a default entered. So yes, you got arguably double dipped, but you owe this money because you didn't show up. We're not going to revisit your defense. You weren't here to raise your defense. Then I had a hearing to set aside the default, which I'm not even sure I can do in small claims court. And I didn't set it aside. Now she wants her money. And then there was a subpoena and you didn't show up for that. I'm trying to determine when that was. That was we did move it.
We moved it, yeah. Today.
You were to be here on 9/29. Oh, yeah, we moved it to this day.
Yes.
Not sure why this is a show cause. Just failed to pay, failed to appear for the motion, but I don't remember a subpoena for discovery. I'm not sure. It's an order to show cause why you should not be in contempt, but I don't see that you missed anything to be in contempt.
I'm sorry.
Yes.
I had to pay the St. Joe County of Mishawaka to have Ashley's Furniture served.
I'm trying to figure out what date that was. I'm looking and it's not in the paper file in front of me.
And then he didn't show up.
Yes, I'm trying to determine what date that was.
I filed, oh wait, let me make sure.
Here's the subpoena. Subpoena was for him to appear on August 11th. and he did not appear. That's why you're in contempt. You got served the problem is you're too busy. You don't show up for stuff. So
I'm also out of Fort Wayne, not, we have a store in Mishawaka, but
yes,
maybe that's what was served. I am out of Fort Wayne.
let's see where the proof of service is. Picked up the plaintiff to have personally served on the defendant. Service of subpoena. It was served allegedly by a sheriff's deputy for St. Joseph County, which would be South Bend. Cost her $88 additional. Well, they served it on Ashley Furniture, Great Road, Mishawaka, Indiana is where they served it, which is St. Joe County. So they served the business, not you. All right, at any rate, the judgment stands, whether it's fair or unfair, it does. So she wants, it was for a discovery hearing, for you to come here, for me to put you under oath so she could ask questions to you about your ability to pay on this debt. Now, you're not an attorney, and I don't hold you to that standard, and neither is she. We're in small claims court, and the rules are more relaxed, but they still are the rules of civil procedure. The hearing you failed to appear for on March 10th I placed Ms. Manley under oath on March 10th and asked her some questions. And she still wanted her $1,699. Failed to appear for this hearing, which was noticed for that day. Then I had a second hearing regarding the request to set the default aside, and I denied it. So you owe her $1,735.42. And she's here because she wants her money, plus 88 additional dollars for the additional service.
Your Honor, may I speak?
Yes.
Yeah, the piece that the court had ordered us to replace, we did. We replaced it and everything.
I understand all that. You missed the hearing. So you want to raise your defense that you failed to show up for and raise the defense. So I was compelled to issue a default judgment. So you dropped the ball to the extent that it's cost you $1,735.42. I understand that you have some defenses you wish to raise. And I didn't enjoy entering this default judgment on March 10th, but you didn't show up. And then I had a hearing regarding why you didn't show up, and I didn't find good cause to find out why you didn't show up. So the ship sailed. You owe this money. Do you want to pay it, or do you want to get another $10,000 worth of bad publicity? $1,735.42 plus 88.
Do I not get the furniture back, Your Honor?
No.
So she gets the furniture?
Yes, she gets a double dip because of your failure to appear for the hearing, which is what stopped. You prevailed. I took testimony. She was unhappy with what she got. She wanted to sue for even more. Ms. Manlin, did you have any other expenses other than the $88 service fee?
Just my loss of wages for all of my work missed.
That's not recoverable in
Then-
small
then
claims.
no.
Was there a filing fee for the subpoena or anything?
Just what I had on the paper already.
All right. $1,823.42. What was scheduled was a discovery hearing. And then her to discover your ability to pay on the debt. You're here, she's here, you're under oath. I don't find that you're in contempt for failing to appear for that subpoena. The officer just subpoenaed your store. And then I don't know what they did with it, put it in a desk drawer or something, but they didn't give it to you and nobody showed up. So I'll take you at face value that you didn't know about that hearing. Then I did this, that you specifically had to be here so we could all be in the same place at the same time. But in order for her to do that hearing, she paid an additional $88 to have a South Bend, St. Joe County, Indiana deputy serve you. So that's where we are. It's difficult to execute on an idle state judgment. If this were in Michigan, she could seize your assets. She could come with a court order with a deputy and take money out of your till, I suppose. I don't think that's ever been done, but seize tools, trucks, that sort of thing to auction to pay the debt. This has been, you've been here 6 times. I don't know. You've both been here repeatedly. I've spent, I don't know, 20 hours on this case regarding this
This is
furniture.
the first time I've ever been here physically. I
Okay,
was at, before it was Zoom.
all right. Well, that's why I wanted to get everybody here. So the question is, are you willing to pay $1,824?
Again, Your Honor, she keeps the furniture. I pay her back for the furniture. Is that-
Yes.
And she's able to keep it. And
Yes, 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 yes. I don't enjoy it. You didn't show up for the hearing. I took testimony. I default entered. She's still unhappy. She wants more than this. So I can't be any more clear. We had a hearing to set aside the default and I denied it. Yes, she gets the furniture and the money. So how does it, whether it's fair or not, that's how this came, because you didn't show up. So if you're not gonna pay her the money, she can get an order to seize your property. And fight it out that way. But,
Hey, ask another question. Your
yes,
Honor.
sir.
And talking to my local attorney, he thought the jurisdiction would be in St. Joe County,
Jurisdictions at both ends.
where you buy it, because we have no stores in
Yes, where she is and where you are. And it's a small claims case. The furniture was delivered to her in St. Joe County, Michigan.
or picked up. I believe it was picked up.
And so,
A repair was
A
sent to
repair.
my house.
Furniture was initially picked up in St. Joe County and at the store at St. Joe County. I'm not an attorney. I don't understand.
I
a lot of the
understand,
things, you know.
but yes,
And our representative from Fort Wayne said he could not represent us in Michigan.
well, you can't have an attorney in small
Yeah,
claims
that's
court.
right.
You can remove it to the general division of the court where she would have had a harder time presenting it following the rules of procedure. All I want to know is, are you going to pay her the money or not? If you're not, then I encourage you to then get an order to seize property. You've got so much bad publicity about this, then it should really have just been resolved a long time ago. She's very diligent.
What, Your Honor, I thought it was resolved, so I apologize for that, and as far as paying, yeah, if you tell me where to send it, I will get it sent out.
All right, very good. Plaintiff will pay within 21 days. Her address is on the complaint and on the judgment. We'll give you a copy of that.
So I sent it to that address.
You
not
sent it
the
to her,
court.
not to the court, to the Youngs Prairie Road address, Constantine, 49042. That's still correct?
Yes, Your Honor.
Yes, I understand that you feel this was unfair. She also feels it's unfair, so man, there's enough unfair to go around. I didn't like her getting the furniture and the money. It seemed unfair to me too. But I issued that order, and I'm not gonna say it for the 5th time. You didn't show up. So, I'll have the bailiff take you out to the court office. The clerks will make sure we have the right address, and you should send 1,824.42 to Amber Manley at her Youngs Prairie Road address. All right, this was a very unpleasant experience for both of you, and for that, I'm sorry, but I'd like this matter to be concluded. All right, 1,824.42 within 21 days.
Thank you, Your
All
Honor.
right, thank you. All right, coming all the way up here for this unpleasant experience. All right, you're both good to go. Mr. Schultz, can you hear me?
Yes, Your Honor.
All right, would you please raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief.
I do.
All right, the title of this case is Daniel Schultz versus Concrete and Excavating LLC Everlast. The claim is for $4,097.24. As in the last case, the plaintiffs have not, the plaintiff is here, the defendant isn't. So let's take a look. Somebody accepted certified mail service for this. Restricted delivery. Certified mail returned. So they personally served Everlast Company in Granville. Sean Woodrow Jr., co-owner. So they aren't here to defend it. In your claim, you indicate you work with them, were given reasonable opportunities to complete the concrete driveway as promised. They failed to show numerous times. You had to purchase $97.24 of material, pay an additional $2,500 to get the rest of the driveway completed, and had to pay a secondary contractor $1,500, which gives us to the figure of $4,097.24. Is that correct?
Mostly, Your Honor. So I believe you're reading off the notes from.
I'm reading off your complaint.
Okay, so the $1,500 is actually above and beyond the total cost of the project that was originally quoted. So I actually paid $4,000 to the secondary contractor.
Yeah, that's, oh gee. Yeah, 2,500 plus 1,500.
So, so can I go over the math with you real quick on it?
Yeah, well, you're asking for $4,097.24. Is that correct?
Yes, sir.
All right, so the 2,500 you had to pay to finish it, and the above and beyond cost of $1,500, which is $4,000. If I got that right?
Mostly. Can I try to explain it a little bit? And this is my math, I suppose. So ultimately, the total cost of the project was supposed to be $10,000. I paid initially $5,000 as a down payment, and the remaining $5,000 would be due the day the concrete was poured and finished. However, mid-project, Everlast Concrete decided to split the pourings, if you will, into two phases, a phase 1 and phase 2. So they actually required an additional $2,500 from me, which reluctantly I gave. So at this particular point, they had $7,500, had only completed part of the project. And then after numerous no-shows, basically I had to terminate their contract, find a secondary company that would then finish the job. And that cost of the secondary company
Who
was
finished the job for you?
it was actually gentleman by the name of Brian, I believe you pronounce his last name Antles, Antles. I'm sorry, I don't know the full pronunciation of his last name. So really the additional 1,500 that you're referencing there, Your Honor, is due to my total project cost being 11,500 as opposed to the quoted 10,000 originally. So that's where that $1,500 difference comes into.
Well, they're here to argue about it, and you supported your claim under oath. If he had been here, I would have raised the fact that I know you and your parents, and my wife's are friends with your mom, and you went to school with my kids, but I don't feel the need to recuse myself. I think I could have fairly heard this matter, but it's a default. So, and you supported your claim with pleadings and under oath. So I find that they owe you $4,097.24 plus costs for a total of $4,229.94. So this is the easy part.
Yes, sir.
Getting the money is the easy part. I mean, getting the judgment is the easy part. Getting the money is the hard part. Which house was this at?
This was at Sean's. And again, I apologize. I don't know his last name. I think you actually read it based on the proof of service report.
Yes.
Yeah, so it was at Sean's address in Granville.
But this is one of the, no. Where is the house? Which
Oh, I
Moore Park
apologize.
Road is it?
Yes, on Moore Park Road in Three Rivers,
I'm trying to picture which house it is.
at the corner of Sunset and Moore Park Road on the southwest side.
All right, got it. All right, you prevail. Now, they have 30 days to pay this. If they don't pay it, you can do what the last lady did and do a discovery subpoena to compel them to come to court to discern why they should not pay on the debt. They're gonna do the same thing. They're gonna show up and say, hey, wait a minute. You know, we wanted to say this. They didn't show up and a default judgment enters. So wait 30 days. If they don't pay, you can come to the court and ask for a discovery subpoena, which they will serve on them, which will compel them to appear under oath and be prepared to answer questions about their ability to pay on the debt. All right, I did not feel the need to recuse myself. They aren't here, it's a default. And so,
Your Honor, I do have a question on that.
all right,
Yeah, just, obviously I'll wait the 30 days. Is that something that the court reaches out to me? And ultimately, how do I go about doing the discovery subpoena? Is that something that I work through the court system on?
yes, you'll have to come to the courthouse.
Okay.
And there's a fee. I can't remember how much it is. Isn't very much, $20, I think.
Okay.
And they'll set a hearing and then they'll have to be served. Now, the last one was served out of state, so it was $88. But they'll serve them and then they'll have to come. If they don't come, then they're subject to a show cause to show cause why they should not be held in contempt. And at that point, I could issue a warrant for their arrest. And although it's hard to arrest a company, Everlast LLC, but we'll cross that bridge when we get to it. maybe this will wake them up. Certainly what often happens is when the discovery subpoena comes and they're compelled to come to court, you don't have to come to court if you're sued in a civil matter, small claims or otherwise. But if you don't show up, you automatically lose and a default judgment enters. If you get a subpoena, that's a court order to appear. And if you don't show up for that, you're subject to contempt, which includes arrest. So let's see what happens. Maybe they'll get this and they'll mail you a check and everything will be fine. That doesn't happen very often, but sometimes it does.
Is this something that I should reach out to them directly and ask if we can come to an agreement outside of court? Or
Yes.
okay,
Yep.
I'm happy to do that. As a matter of
Well,
fact,
you'll get this. Why don't you wait a week or so till they get a copy of this default judgment?
yes,
And
sir.
then you can contact them and say, hey, can we set up, $500 payments or something?
Okay.
But yes, all right. You're good to go. Thank you.
Thank you, Your Honor.
All right. All right. He's a nice young man. He's working on his own real estate portfolio.
Hi. Is Denlar here? But I'm gonna go on to this real quick. This Wyatt check. Put those right there. Monica Leanne Wyatt check, 24G 305-990A. So your name, ma'am?
What? Just go to have up the race.
Took her plea to being positive on a chemical test on September 16th. I ordered her to test that day on November 29th. So the court date was September 29th, rather. I took her plea, told her to test today, set it for sentencing. She didn't go test. Why didn't she test?
That wasn't my intention. I had every means to go test.
Why didn't she test?
Well, I only had one vehicle with my husband. He jumped off on me and thought I'd had other people to call. I called everybody that I could.
What else happened? What else happened? Did she miss another test or?
I believe so. She just didn't appear for that day, Your Honor.
Are you sure?
I have to double check.
Please double check. Hang on. Please double check if you need to. I don't understand this, Ms. Wycheck. You live in Gibraltar, right? You tested DNA, right? You couldn't take an Uber, you couldn't get a cab, you couldn't get a Lyft, you couldn't get anybody to drive you, and you didn't have a bike to drive.
I didn't have any.
You are forcing me to send you to jail now. You can't do this.
Test today.
No, I don't want you to test today. I think you're on a bender is what I think. That's what I think. And Emily would tell us that if she was here. Ma'am, when I tell somebody to test, I didn't ask you to drive to Oklahoma. Don't come in here and come in with this. I was feeling sorry for you. I thought, okay, she's almost to the end. And then I'm getting statements from the probation officer that, did you send the probation officer a email?
Yes.
Pam, I want to see if there's emails from Ms. Wyachek to Emily. Sometime, if you guys can get in her computer, or emails after the 29th, up until say the 2nd or 3rd, if you can check, okay? Do you have any information on that?
Her caller hasn't been called since the 29th.
Yes. No. I'm talking, hang on. There was some email that was sent to Emily. I need somebody to find that email. It was either the 29th or the 30th, possibly the 1st, by Ms. Wyachek. Okay? Thanks.
Her caller was called this morning, but she technically still could test this evening for testing.
Judge.
I have that reporter's line, so.
This is not good.
Orange. And now.
Well, let's not worry about that. Because we can clarify whether your color is orange, lime, purple, pink. The point is that I told you to test and you didn't go test. This is not some voluntary testing facility we have next door. It's not go if you feel like it. She's in trouble. I was worried about her in the very beginning. I mean, you drove into the back of a patrol car. You drove into the back of a patrol car.
Very seriously.
Well, you didn't take it seriously on the 29th when I told you to go test. I mean, I don't want to sit here and
A lot of personal things. My husband has health issues. I'm on the verge of losing my home. I'm having a lot of things that happen all at once. I'm trying to get a job back in his work. He's waiting to go back to his job, so he's working. He's gonna be working by the end of this week. And we've been broke.
why'd you lose your job?
I was working 15 hours a day for the past 2 years. And I'm pointing out, when you point out at where they have to let you go.
You pointed out due to what?
Just being late or
Yeah.
throughout the amount of time.
I mean, I don't want to. You seem like a really nice lady. I thought that before. I think it now, but I'm not surprised.
Been trying to.
I'm well. You got terminated from employment because you were irresponsible. I'm sorry. I don't know what to tell you. You are.
Balancing all of this by myself.
Well, you have a husband, right?
Good. He's got health issues. He's hasn't been around like that. And when losing his job, made him go into a mental breakdown. So I've been doing all this by myself.
How many children do you have?
My son's autistic.
What do you have to say?
Which, I think at this point with such a recent positive, and it's kind of a red flag when you get a positive. Like, I think there's only 10 more days before it's just going to be off probation. I would ask the court consider continuing the probation, and maybe a coffee.
You were going to be positive. You can tell your lawyer what you want. You can tell anybody else what you want. You're not going to fool me. You were going to be positive for alcohol on the 29th, which is why you did not go and show up and test. Ironically, I'd made up my mind that if you went and tested negative, that I was going to be very lenient with you. When people don't show up for their testing, they are sending a clear sign that they are going to be positive. And I'm going to consider them to be positive. Well, you can shake your head all you want, but I'm telling you, I feel very strongly about it. Nobody's going to convince me I'm wrong. Yes, there are things that happen, but I promise you, if I told you I'd give you $2,000 to show up to DNA testing that day, you'd have been there. Ma'am, don't interrupt me. Don't interrupt. Why weren't she able to?
She wasn't around during that time to from media. My husband was going through mental breakdown. I have the ties of him threatening me and wasn't able to cope. I wasn't able to get out of the house.
Where was he at? He left for where?
And he just took off. And he's He's been bipolar. Going back and forth. Jane stated that it'll take a few minutes for him to recover the email if it's there.
And just to clarify what to expect, I was aware that there was email and it looks like it was sentence, just half of a sentence. Really no content.
I'm gonna have them retrieve the email.
If I could, we do have a letter from her therapist, and I will note in the therapy, it does state that she's compliant with the current plan. Her prognosis is looking good on the treatment, but it does state here, the therapist stated that she reported to her that she quit her job, not that she was fired.
I don't care if you quit. I don't care if you were fired because you weren't showing up or showing up late, or a combination thereof. You're 30, how old? Just can't. You just can't ignore court orders. Do you have a valid license right now? Yes? Why didn't you drive to DNA?
Have vehicle.
How many vehicles do you and your husband own? Have a seat. I'll see what happens when he pulls the emails, okay? Brian Lee Botts versus China Badiak and Kelvin Pruitt, 2503584.
Mr. Podium. Yeah, I have my realtor here to speak on my behalf because it's a realtor contract.
I mean, he can be called as a witness, but he can't represent you. Come on up here, everybody. He can come up. Sir, what's your name?
Ryan Buck.
Ma'am, your name?
China batted, Your Honor.
And your name, sir?
Kelvin Pruitt.
All right, and your name, sir?
Jerry Bobbitt, Synergy Realty Group.
How do you spell the last name?
BBINTT.
Jerry.
Yes, sir.
All right. Plaintiff and defendants, you have the right to have the case removed if you want. You don't have to proceed in the small claims division. If you choose to do that, you can. If you choose to have the case removed, you'll have other rights that you won't have by proceeding in the small claims division. Let me put it another way. If you proceed in the small claims division, you're waiving the right to hire a lawyer. You're waiving the right to have a jury trial. You're waiving the right to appeal my decision. And plaintiff, to the extent that you may be entitled to it, you're waiving the right to seek in excess of $6,500. Do you understand that? Sir?
Yeah.
All right. Do you waive those rights? You want to have the case removed?
No. Maybe I don't understand what you're saying.
If you proceed today in the small claims division, you can't appeal my decision. You can't hire a lawyer to represent you on this. You can't have a jury trial, and you can't seek in excess of $6,500, even though they might owe you $50,000. Do you understand that?
Yeah, I understand.
Do you understand those rights? Do you?
Yes, sir.
Do you wish to waive those rights and proceed here, Mr. Botts, or do you wish to have the case removed to the general civil division?
I will continue today.
You waive those rights?
Yeah.
Do you, Ms. Badiak? Got to keep your voice up.
Yes, sir.
Do you, Mr. Pruitt?
Yes, sir.
Raise your right hands, all of you. Do you solemnly swear or affirm under the penalties of perjury the testimony you'll give in these proceedings be the whole truth, so help you God? Mr. Botts?
Yeah.
Ms. Pruitt, Ms. Badiak?
Yes, sir.
Mr. Pruitt?
Yeah.
Mr. Bobbitt?
Yes, sir.
All right. Let me just take a quick peek here, see what this one's about. It says, defendant refuses to sign your lease of escrow deposit of $3,000 for structural damage. They're mad that the pool wasn't clean and ready for use and for outside fence to dry rotting. All right. I don't understand. So the defendants bought a house from the plaintiff?
Yes.
And how much was the purchase price?
$75,000.
What's this about?
The seller was late moving out of the house. The house was not room clean. pool was unusable and I spent more than $3,000 fixing the mess. Contracts.
Wait, slow down. When did you close? When was the close?
In June. We closed maybe on June, it was in June.
Well, I know, I need to know the date. Can you tell me, Mr. Bobbitt?
I only have the escrow here that the date they were signed, so I do not, I apologize. It's about approximately 45 days.
We closed on June 11th.
And that purchase price was $475.
Yes, sir.
And there was an escrow deposit. Yes?
Yes.
What was the escrow for? Can one of you tell me over here?
It was a damage escrow for $3,000. For damage. Struck. So.
Yes.
So there's a $3,000 damage deposit that was given.
By
Damages.
by the
Mr. Botts held it. It's with Michigan Title.
okay.
So it was $3,000 for any damages that were done after the day of the purchase agreement. They have to leave it in the same condition or in better condition.
Right.
The defendant is stating that the property was left in disarray. When we showed up, the agent wanted him to sign a key release, which he refused to sign, and a damage report, which he refused to sign. I did have the agent write on the back what his complaints were as far as the damages. As far as damages go, he mentioned two things. One was a patio gate or garden gate that was damaged. And two was the pool was left not to his standard. So I did bring a picture, but unfortunately, Your Honor, we don't take pictures to try to show damage. But it was an old fence.
Let me stop you a second. When did you guys enter into the purchase agreement?
The purchase agreement was originally initiated in April.
What date? Can you tell me, Mr.
I
Bobbitt?
do not, because I didn't bring the purchase agreement.
I do have
It's a
it.
damage.
Okay.
You have a purchase agreement here.
July 1st.
July 1st.
Yes.
All right. So that was the PA date. You closed on. Wait a minute. Wait a minute. I thought, am I missing something? I thought you guys just,
Closing date is July 11th. It's right here on the addendum.
wait a minute. Slow down. I thought you told me June 11th. Did you not say that or did I write it down?
Okay, July.
Is it June 11th or July 11th?
He said it earlier on, that's only.
You got to talk to me. Don't talk to him. You got to keep your voice up for me, okay? I thought you told me that the closing took place June 11th. Did I misunderstand you, Mr. Pruitt?
Yes, I was meeting July 11th.
Okay, so July 11th closing, right? You guys closed 11 days after the purchase agreement was entered into?
No. April 22nd was the purchase agreement date.
April 22nd was the purchase agreement date when we did it all.
All right, so then you didn't close till July 11th.
Yeah.
And your complaints were the pool was not up to your standards and there was a portion of the gate that was damaged, right?
No, sir, that's not what we're bringing to the table. That's what they said. We have other things that were out of range, dismantled. They left all kinds of garbage. They left their entire room upstairs. They left.
All right, slow down. Be specific. What was the problem that entitles you to the $3,000?
So-
One at a time.
So the pool was green. It cost, you'll see with the receipts, it cost me $1,200 for the pool. The house is supposed to be.
To do what?
To get the pool cleaned.
Backwashed and all that.
Backwashed and cleaned out to the point where it was even usable.
You have a picture of the pool?
Yes, sir.
Can I see the pool? So pool was number one. What's number two?
Thank you.
Jeez.
Exhibit 1 is the pool.
Yeah.
Then there was trash in the sheds, trash in the driveway. They left military, someone's military out of the lungs upstairs in their house. They had a fence that they tried to take down. They left dog poop in it, a lizard. It's a lizard at the house.
You left all this like this?
Yeah.
Well,
The only thing I did leave the pool read because I didn't use it.
Well,
In the whole agreement, look, house drawing. The pool stayed drained to the bottom house.
Wasn't open.
It wasn't open when we looked at it, Your Honor.
And the pool was on for his graduation party. You see where it says grand all in there? Those are his pool floaties that he threw his graduation party.
There. It used.
all right, hang on, slow down. Well, I know, but you still. So you got all this garbage here. Did you see these
The
pictures?
garbage is at the curb where I was supposed to put the garbage for the trash to be collected, or.
They wouldn't take that, Your Honor. We had to schedule another pickup for them to come
How much did that cost you?
of the city.
City pay.
The city picks it up, there is no fee, Your Honor, there's unlimited trash, that's what it's.
All right, slow down. You can't, wait. Both of you can't be talking at once. See this picture here? Can you all see that?
Yes.
What does that consist of? That looks like,
I was there when I purchased the home originally, sir, I never touched or used the stuff that was left there.
looks like ceiling tiles. Am I right?
I'm not sure what it was.
Yes, Your Honor, it was, drywall, things
All
that,
right. What'd you do with that? You threw it out?
Yes.
Did it cost you any money to throw it out?
Okay.
All right. What else did you have to expend money on? $1,200 for the pool. Do you have a receipt for telling me that it cost you $1,200? Hand that up.
Now I'd like to add, I offer you a purchase down for you.
sir.
It takes 2 to 4 bags of shot to open the pool up. And someone moves around and it decides it being bad. And the part of the pool is not part of the structural damage because the water is green. It's the structural damage deposit. It doesn't, green water isn't structural.
Who did this? It says guest check, Flat Rock Home, $395, 3 days.
It was our cleaning lady came, Your Honor. They were supposed to have it broom clean and everything.
Who's this? Who's the cleaning lady?
Rhonda,
Rhonda what?
I'm sure that's name.
So you got 1,200, you got 395. What else do you have?
We took off 3 days of work,
Who did?
myself and my husband, because they were supposed to be out on the 11th. And we didn't get ownership to the house until the 15th because they stayed 4 days over. Wouldn't get out of the house, couldn't get a hold of nobody.
And then
Wait a minute, slow down.
we tried.
Slow down. Wait, stop. I need to digest this. So you're telling me that on the 11th you closed
Yes, sir.
and he was still in the 15th. Did the
Yes, sir.
purchase agreement provide for immediate occupancy?
It did not, Your Honor.
Would it-
Yeah, we had, no, there's actually
What did it provide for?
free occupancy.
Free occupancy?
No,
I gave them
Whoa!
I gave,
Wait, guys, wait. I just had 4 of you talking at the same time. You know the chance for picking this up and doing it correctly? Come on, one at a time. I directed my question to him. If I'm looking at you and I'm asking you a question, I want you to answer it, not somebody else in the hallway or here, please. All right, let me see the purchase agreement. It provided for free occupancy for how long, Mr. Bobbitt?
I think it was 30 days.
Well, it said sellers will vacate the premises. All personal belongings will be removed on or before August the 10th. Did you guys not hear?
Listen, things.
They don't have any, you usually have, why was there no, doing it again? Hang on, you're doing it again.
I was raising my hand, I want to ask you.
I was looking at him. Well, yeah, why was there no rent escrow, no daily amount?
Because it was free occupancy after closing. So there was no rent escrow because no.
So I can't penalize them for staying in the 11th through the
For
15th.
30 days they got it. So from
So-
July 11th to August 10th was their free 30 days. They were supposed to be out August 10th.
Paragraph 26 says possession will be given 60 days after closing, or
That's what our addendum said. We agreed to 30 days. Our agreement was for 30 days. It says it on the very end of they will have their belongings out on August 10th or before. It's on the very last page that we all signed and agreed on.
you're gonna have to show me.
So if you flip it back at all.
Seller will vacate the premises. All personal belongings will be removed on or before August 10th of 25. When did he vacate?
August 15th.
Okay.
Still moving.
Well, there wasn't a hang on. There was an addendum here that says you were to be out by August 10th and you were there till the 15th.
Yes, I was, because I wasn't allowed to get into the home I purchased.
Well, you guys have a mortgage?
Yes.
Yes.
Okay. So, I know what I want to hear. I will come to you at the end. I promise you. I will hear every single word that every single person says before I make a decision. Is your mortgage, taxes, and insurance all included in your monthly mortgage payment?
Yes.
You sure?
Yes.
So you pay your taxes with your mortgage and your homeowners goes with your mortgage. How much is that a month?
$39.70.
Can you do me a favor? So he's out 4 days late. Yeah, but Amy, you have a calculator there. Okay, now I'm prepared to let you finish.
Original agreement, they're be out by August 22nd. It was based on us buying a home purchase. I also gave the defendants $20,000 to buy the house. $10,000 in the cost of the house and $10,000 out of my account. I moved as soon as I can move. And I looked at houses almost 5 or 6 a day, over 40 houses per month. So the quickest we could get out there was on that day because the owners of the house we bought would not allow us access to it.
Slow down. Do you have a calculator down there?
Look it up on the computer. Oh, no.
I think Tabitha has. John, would you? Wait a second. You signed an addendum on July 1 saying you would be out by August 2, right? Okay. So whether the new whether the house you're buying was available or not because the sellers hadn't moved out is not their concern. You understand what I'm saying to you? You just need a calculator.
You tell me what to put in. I have it here on the screen, but I don't.
I want to know the daily charge. Take 3973 divide by 30.
132.43.
All right. Times 4 should be 520, should be 530 or 529. All right. What else? Are you telling me you're sure that the gate was damaged or not damaged until after you signed the purchase agreement, but before you signed before you closed on the property?
In the yes, the fact that years before and the pictures, one of them is written on the top. It says "Doris," a picture of the home. And I believe the picture I tried to make it so immediately has the gate now.
What's this? The garage door? What happened to the garage door?
Some kind of way when we bought it, it was not ripped up like that. I do have photos actually of the inspection.
How much did you have to spend for that?
I haven't been on the fire on that. It's the natty that's completely ripped and torn apart.
I don't know where you're saying that the gate, you have before and after pictures. I see. Let me just double check.
You're on, I do have it before. I don't have it. You want to go in forth?
Sure. Why did you leave all this junk on the floor?
What? What about it's back.
You can show that to him. Yeah, you can come right there.
I don't know any of that because that room was empty when we moved out. That's not my belongings.
Your Honor,
My realtor and their realtor did a walkthrough together to verify the damages or room's conditions of the home. I wasn't there for that.
Okay, go ahead.
Your Honor, so when they refused to sign, the agent had them write down in their writing and sign exactly what their concerns were and for the reasons not wanting to sign. the damage escrow. And for as far as damage goes, they mentioned two things, which was the pool and they mentioned the fence. The fence, I would agree with them. It was already damaged. The pool, I would also agree with them. It wasn't left in the greatest condition. So that's why I said, give him money for the pool, for the shock. He said $200. I was texting back and forth with their agent. Their agent said absolutely not. They were going to go after a lot more.
Well, I mean, the pool was green and he's got a receipt here. He's got a receipt indicating that he spent $1,200, right?
We were never given that.
Well, let me show it to you now.
Now this one here, 4 years, yeah, pool fire it is. It doesn't take, anytime you uncover your pool for a winter, it's 70 degrees.
Of course.
And I spent $50 in shock and chlorine for my daughter's graduation party. And after her party, I didn't continue paying out of my pocket for the pool I was not going to use. And the color of the pool did not determine the degree of them bursting in the house. And there's no structural damage whatsoever, not even to the pool. You can't damage a pool because the water's green. They can be shocked out, but if you're not swimming, you can put 200 pounds of shock in there, and it's still going to be green unless someone's in it moving.
Your Honor, he just said he didn't use it.
I had it pulled
Earlier today.
What do you want to say, Mr. Bobbitt?
And I mean, this is up to Your Honor. He had it clean for $1,200.
Right.
Then he had it winterized.
Yes.
I'm just, why would you?
Well, you said it winterized since, right?
Yeah, pool closing with chemicals. Yeah, he paid.
This was at the end of August.
Pool
That's the one
closing.
past August in Michigan. So we
She's
cleaned
not
it
wrong.
and we closed it.
Let him finish.
But we pool closing with chemicals 400, then a rectangular pool cover for 200, and then 10 water bags. I don't know what that's for.
He's not asking for that.
No.
So,
He's asking for the 1,200.
but with the 1,200, okay, and I apologize. With the 1,200, Your Honor, to clean a pool doesn't cost $700 just to shock it and clean it, and then you have the filters cleaned for $500.
The filter was in really bad shape. We had to get a new filter. We couldn't use that filter because of how nasty it was. It would have kept the pool dirty.
There's some other aspects though.
I'll bring the pool tech, if you want to bring them back and reschedule.
Right, and our realtor can come as well too because we have a realtor.
Wait a minute. Wait. I can't have you guys talking to each other or talking while others are talking. Please don't address the other side. Address the court. If you convince him you're wrong or her that you're right, it doesn't matter unless you convince me. All right, go ahead.
So, I mean, so as far as getting it clean, personally, it's a little absorbent. Like I said, I thought $250 was more than a fair offer to buy the shock to get it cleaned. Because the pool was earlier in fine condition. So a month and a half that it may not have been shocked or chlorine isn't going to cost $750 worth of cleaning. That being said, when I asked him, or the agent asked him to name everything, this is a damage deposit escrow. It wasn't a Brent's escrow or a holdover escrow. It was just for damages. And the two things that he mentioned, pool, that's up to your own, discretion. And like I said, the fence was already damaged. It's an old wooden fence. So again, to have any claim on a fence, I didn't see deemed necessary. That's why I did speak with Mr. Botts, seller, and saying, I think you did need the pool in an unkept condition to clean it. So the rest of the house was in a very clean, room swept condition.
Your Honor, his son actually was the real estate agent. He was apologizing to me for the state we got the house in. We went to buy our dream house, and this is what we walked in.
All right. And you're saying the $3,000 is with Michigan Title? I'm not sure how to do this. I wish Michigan Title was a party.
Sure. All we need is four order stating house is supposed to be this.
I know.
And I'll forward that to Michigan.
I know. it would have been easier if they were here.
We had started in April with the Box family trying to get this house. And every time we had tried to come up with an addendum or tried to figure something out, it was always on their end. They couldn't do something. So when they were trying and looking for their new house, their credit wasn't good enough. So we gave them another 30 days to get their credit together to buy the house. Then we gave them another 30 days. We continued and continued our generosity for the Botts family until it became there. All that stuff up there was the military members. I'm a veteran, Your Honor. They had dog tags. They had old uniforms. It was not our stuff. All that he showed a picture of was his stuff, Your Honor. It was us taking off work to move in, then we couldn't move in. Now we're missing $200 days because of our
All right,
work.
slow down. Just slow down. How much was the damaged escrow deposit?
$3,000.
Feel funny about telling somebody else to, that's not a party here. Jeez. All right. And you bought the property at 401 Arsenal, right?
Yes.
Okay. I don't care what did I let everybody finish now? I want to make sure that everybody is finished. Let's start with you, Mr. Botts.
I just know original agreement, we agreed to be outlined August 22nd at the latest, and I looked at it, had that time to buy the house. Not to mention that I already thought I can treat them good as a veteran, but I feel like they're greedy because someone gives you $20,000 down to buy a house. You should be a little appreciative. There's no appreciation there. It's just give you again. That's the big though. Passion trying to change their denims. That's how that escrow damage money got in there. That wasn't originally part of the agreement. That happened later down the road once. Everything was falling through.
Anything, sir, you want to say?
No.
Miss Baviak?
Yes, Your Honor. He didn't give us $20,000. That went towards us paying the $475. That was him putting it in the escrow. He didn't give us any money.
$10,000 I did too.
All right.
No.
Don't interrupt. Don't interrupt. Go
Your
ahead.
Honor, if I knew we could bring our realtor, I would, to break it down and explain to you where the money went and how it went. He didn't give us any money. Every time we tried to get a hold of him and come up with an agreement, it had always been on his side. What he needed, how many days he needed, finding a house. We were almost gonna not be able to get into the school district because of how late the dates rolled over because we were also changing school district. So we gave him as much time as we possibly could. On the 10th, we couldn't get a hold of nobody. I know his realtor was, again, apologetic, sorry the way things happened, said he didn't want to deal with them, couldn't deal with them, that he didn't understand what was really going on. So we didn't get any answers of when he was moving out, what day. We had to reschedule twice, our moving company, things of that nature, like stuff we didn't put in the packet. He left his dog poop all over his dog cage, tried taking that,
All right.
couldn't get it in time, left a mess.
Anything else?
The original selling price was $464. When they raised it, that was the money he saw. So it wasn't given to him. It wasn't like I got any money out of pocket, right? And even with this escrow deal, I tried to contact them several times to come up with a solution. I offered $1,000. We offered $1,500. They refused everything. They would not contact us.
All right.
So
I've heard it. Thank you. You got to leave the property in better condition. Yeah, I'm done. I'm ready to talk and tell you why I'm doing what I'm doing. You have to leave your property in better condition. You're talking about a gate. You're talking about a green pool. You're talking about leaving garbage and things in there. And there's something about the damage to the gate as well. I'm going to give you $800 on the, I'm talking about you two, on the pool. I'm going to give you $539.73, which represents the 5 days. Listen, you can shake your head, but please do it outside, okay? Mr. Bots, you don't get to stay over. I don't care why it is. Their mortgage, their daily rate is $132.43. That means you're going to pay them times the number of days that you spent there. We also have a cleaning fee from a cleaning lady, and I'm going to cut that down. I'm going to give a judgment to the plaintiff for $1,350. I'm going to order that Michigan Title release $1,350 to the plaintiff and $1,650 to the defendants, and you can all take back your property, whatever exhibits that you have that you'd like. Okay, that's the ruling of the court. You can both go down and get a copy of the judgment. Okay, there weren't counterclaims filed here. There should and could have been. I try to work these out, small claims, the best I can. And those are all either in the file or down with you. Good luck, everybody.
Yeah.
Hang on one second, Mr. Bobbitt. I'm going to trust you're going to take that order over to Michigan Title.
Yep.
And tell them what I said. And they can call me if they need to. Yes, ma'am.
I also have malapis that I'm trying to return to UPS. If he wants to take it, I'll give it to him.
What's this guy doing? Leaving already? Or whatever. I don't know what to tell you. Return to sender or forwarding address. I'm not dealing with that. That has nothing to do with me. Thank you all.
Thank you.
Have a good day. You too.
I can get it to order. I can get an order.
Yeah, they'll give you a copy of the order. Tell them to give them a copy of the order down there. Will you, John, please?
Yep.
All right. What else do I have down there, ladies and gentlemen? Calling Monica Wyachek, 24G305 9908.
That's what I'm looking for you.
Sure, when it's different, not the less.
We were able to get into Emily's emails. The defendant did send an email on Monday, September 29th at 12:47 PM. Quote, please help me tell the judge, ... That was it.
Were you drunk?
No, that was actually my husband. And then he ended up calling her.
You got a drinking problem. I mean, I'm sorry. That's what I'm seeing out of this whole thing. I'm not trying to make you feel bad. You're making a lot of excuses. I think you're rationalizing. I don't know why your husband thinks he can send something to probation on under your name. I know what's going on. I can tell. I'm serious. I'm not trying to make you feel bad. I'm trying to figure out which direction I need to go. You didn't show up because, as far as I'm concerned, you were drinking within 3 days and you knew you'd be positive. You can give me all this about not showing up because your husband threatening you. Your husband, who was threatening you, I think you said earlier, is now sending emails. On what day was that?
September 29th, the last.
September 29th. And he's sending emails and you're telling me he's threatening you, and September 29th was the day that you were supposed to test. Young lady.
I was actually thinking about moving out and moving in with my mom for a little bit with the kids. So it'd be easier for me if she's willing to help me with everything now that she knows the gravity of my situation.
Anything else? I know it's a tough one because she's almost forcing my hand here. Anything you want to say?
Jail, but if the kids need you, I don't know, fall apart in housing.
What are you thinking?
When I had a conversation with Emily's recommendations to jail. I've been taking this seriously from day one. I've been doing everything. I've been working so hard from 3:30 until 3 in the morning every day just to try to maintain all of our bills. I got my kids.
When did you lose your job?
It was August 13th, but I wrote that late. It was for me leaving early because I kept getting out at 30 in the morning. I had to leave early a lot of times, like kids. My boss, he didn't want to let me go. It's just how the plan system works. I was always there. I was always a hard worker. They didn't want to let me go. He even told me if I put my 2 weeks in, he'd hire me right back. But I couldn't afford to stop working at the time. I had to keep going. My understanding was that my husband, Tom, and his chairman, did every day at work, that they were gonna have him start back work last month, but they're just dragging it on. And they keep telling him to just be ready to work, and it's just creating, all this debts that we're getting is creating him to on this mental breakdown. I've been having to hold it all together on my own. I have a time, that's why I've lost the first time, but I am. And why? I don't desire it from you all important, Your Honor. Honest to God. Just have a really hard time balancing all this. I had no choice to ask my mom for help, and he had no choice to ask his peers that he doesn't even talk to for help. To pay our mortgage, so we don't lose our home. That's all it's doing right now. I have 5 interviews this week, but I'm determined to get it done. And he's supposed to start work next week for his mom's husband's work. He's supposed to go out there and just work for him until he gets called back for GM. That we have something to get us by until then. But I plan on going to work. I want to get a different job other than working from 3:30 to 3 in the morning so I can be there to take the kids to school because they go through all the different schools. And I wanted to work in the morning.
When was that email?
12:47 p.m.
In the afternoon.
Yes, the viewing would be between 5 and 7 p.m. that night.
Oh, why didn't you go then? So you're saying your husband's sending something to probation, or at least this is.
And I wasn't able to go because it was only from 6 a.m. till 9. I could only go between 5 and 7.
September 29th
And I was here.
was a Monday.
They're always open morning and evening.
Why didn't you go that then?
I couldn't go anymore. I was here. So I
At night. Why didn't you go at night?
could only go between 5 and 7.
At night.
Yeah, I couldn't get there. I didn't have any money. I didn't have any transportation. I tried calling everybody. I couldn't get there between 5 and 7. I had all the kids. I had no money. I had no transportation. Everybody was calling me the next morning. My mom was waiting. Usually she's there all the time. Like I could get a hold of her any day, at any time, but I couldn't get a hold of anybody. I've been taking this seriously. I don't miss anything. Even with the sober league,
You missed it.
I think I did everything right.
Man, stop.
I can't.
Stop. Stop. I don't know what's going on with you. If I order a sober link, you're going to tell me you can't afford the sober link. I order. Well, you needed to afford the.
I could have a job by the end of this week. I know I can.
Lisa? Can you hear me, Lisa?
Yeah, I can hear you.
Will Gibraltar send? I don't know where she's going to go if I give her 3 days. Do you? Where Gibraltar will want to send her?
I'm not sure. I can call and check.
Please do. When is probation scheduled to expire? October 18th, right?
Yes.
I can hear you.
Okay, they said they normally would go to Flat Rock, but Flat Rock does not accept females, so she'll go to or to downtown.
I thought you were going to tell me that. That was not the answer I was looking for. I do not relish sending people to jail. I don't relish it. But you got to wake up. No, you're going to serve 3 days jail. We're going to put right on the commitment until 5 p.m. on Wednesday. You're be on a SoberLink device for 75 days. To be on SoberLink by 10 a.m. What time do they open? You know,
7 a.m.
by 10 a.m. on 10/9/25. You're to pay additional costs of 50, additional probation fees of 80 because I'm extending your probation until February 18 of 26. So you're gonna be on probation until February 18, 26. You're gonna pay additional costs of 50, additional probation fees of 80. You're to serve 3 days jail from now until 5 p.m. on Wednesday. I just want you to think you're to be on a SoberLink device for 75 days until October 9th. Ms. Wyachek, you seem like a really nice person. I think you got to get your life in order. I don't know what else to tell you. I don't want to. That's the last thing I wanted. I'm sorry, ma'am. I really am sorry. I really am. Good luck. I'm sorry. And you have to be on that SoberLink by Friday morning at 10. So you're going to be back on a SoberLink by Friday morning at 10 a.m. On Thursday morning, Roger. You're getting out Wednesday at 5 o'clock. Yes, ma'am. Right now.
I have to have somebody take me to jail right now.
Yes. If you're not going to have them, we're going to lock you up. I'm sorry. We'll, we'll let you make some calls. I promise you. Okay? What do you guys need from me? You need something?
Yeah, sorry, under your warrant, you got the judgment of 1350, but at the bottom, I'll exclude the explanation.
I know, because I'm ordering that the plaintiff get 1350, and I'm saying Michigan Title to cut a check to him and his wife for 1350 and them for 1650.
Okay. So you guys got suits? Yeah.
So you're going to take that over to Michigan Title?
I thought it was transposed. I thought Mr. Bach was getting the 1650.
No,
And they were getting.
no. And you have to have them call me, please, if there's any issue. All right?